Welcome to the National Crime Victim Law Institute's online toolkit. Toolkits, which include a combination of videos, downloadable resources, and other interactive exercises, are part of the larger universe of resources that NCVLI offers. In addition to these toolkit resources, you can visit NCVLI's website at www.ncvli.org to access additional free resources, including a number of in-depth articles in NCVLI's Victim Law Library. You can also visit our website to request additional technical assistance and trainings on victims' rights related topics.
This tool is on trial level standing. This tool was made possible in part by a subgrant from the National Organization of Victim Assistance through the Office on Violence Against Women and in part through an award from the Office for Victims of Crime. Our learning objectives are to distinguish explicit and implicit standing, identify key elements of standing, and articulate why standing is critical to meaningful rights. So what is standing? In the context of victims' rights, standing is what enables crime victims to assert their rights and seek remedies for violations of their rights. Our first learning objective is to distinguish explicit and implicit standing. So let's begin with explicit standing. An example of explicit standing can be found in the Federal Crime Victims' Rights Act, also known as the CVRA, which is codified at 18 U.S.C. section 3771. A list of victims' rights are included in subsection A, and the content displayed on the screen is included in subsections D1 and D3. In short, subsection D1 provides that the crime victim may assert the rights described in subsection A. And in short, subsection D3 provides that the court shall take up and decide any motion asserting a victim's right. The CVRA, therefore, is an example of a federal statute that explicitly provides that a victim may assert their rights and that the court must act on the assertion of those rights, or, stated differently, that the victim has explicit standing. Courts have also recognized explicit standing for crime victims. For example, the U.S. District Court for the Southern District of Florida provided that it is apparent through the passage of the CVRA that Congress has enacted a statute expressly conferring certain legal rights upon crime victims, the invasion of which creates standing to seek relief under the CVRA, even though no cognizable injury would exist without the statute. In addition to civilian criminal courts, military criminal courts have also recognized a crime victim's explicit standing. The U.S. Court of Appeals for the Armed Forces in LRM v. Kastenberg not only held that the military-connected victim had standing, but also clarified that the victim's status as a non-party did not preclude the victim from having standing. More specifically, the court held, among other holdings, that the military judge erred by denying the victim the opportunity to be heard through counsel, which in turn denied the victim due process under the Military Rules of Evidence, the Crime Victims' Rights Act, and the United States Constitution. So we discussed some federal examples, both statutory as well as case law. Now let's look at an example of explicit trial level standing at the state level. An example of explicit standing can be found in California's state constitution, specifically in Article 1, Section 28. A list of victims' rights are included in subsection B, and the content displayed on the screen is included in subsection C1. The portion highlighted in blue, or teal, which provides in short that a victim may enforce the rights enumerated in subdivision or subsection B in any trial court with jurisdiction over the case as a matter of right, is an example of standing explicitly afforded to crime victims per statute. Each jurisdiction is different, so it's critical that you check your jurisdiction-specific laws. Before we delve into implicit standing, let's take a look at this true or false question. If a jurisdiction does not have explicit standing for crime victims to assert and seek enforcement of victims' rights, the practitioner has exhausted all research options and need not look any further. True or false? The answer here is false. Let's discuss why. Standing is not a new concept, and it is not only afforded in the context of victims' rights. So we have other places we can look for standing as well. Victims are considered a non-party or a third party, and courts have routinely recognized third-party standing. In fact, there is long-standing precedent that a holder of a privilege has a right to protect that privilege. This means that third parties whose rights have been implicated or stated differently are at risk have routinely been recognized to have standing and have therefore filed pleadings with respect to their rights at issue. For example, courts have routinely addressed standing in the context of a subpoena ducis tecum that seeks a third party's private or privileged information or records. And courts have also routinely addressed standing for third parties such as the media, oftentimes in the context of the First Amendment. Each jurisdiction is different and each issue is unique. This requires legal practitioners to research their jurisdiction-specific standing. Let's revisit our earlier true or false question. If a jurisdiction does not have explicit standing for crime victims to assert and seek enforcement of victims' rights, the practitioner has exhausted all research options and need not look any further. True or false? Great job, the answer is false. Let's discuss implicit standing next. In these instances, we need to turn to a standing test. The test that we will be looking at today, in a nutshell, can be broken down into 3 elements. Let's begin with a multiple choice question. The Supreme Court of the United States provided in Lujan or Lahan v. Defenders of Wildlife that Article 3's constitutional minimum standing requirements are A. An injury, a bad actor, and ample time to challenge the injury. B. An injury, a timely challenge to the action, and proof of the injury. C. An injury in fact, an injury that is fairly traceable to the challenged action, and a likelihood that the injury will be remedied by a favorable decision. D. An injury that is not harmless, a bad actor with intent to cause harm, and presence in court to challenge the action. The correct answer is C. The Supreme Court of the United States said that over the years, our cases have established that the irreducible constitutional minimum of standing contains 3 elements. When we first look at Article 3's constitutional minimum standing requirements, it can look complicated. But when we chip away at the language, we are essentially left with 3 elements. To simplify, those constitutional minimum standing requirements are injury, causation, and redressability. 1, 2, 3. The Supreme Court described an injury, or an injury in fact, as an invasion of a legally protected interest that is concrete and particularized and actual or imminent. So what does this mean? In the context of victims' rights, when we see the term invasion, we can think about a violation of a right. And when we see the terms actual or imminent, we can think about a violation that has occurred or is about to occur. Again, in the context of victims' rights, when we see the term or phrase legally protected interest, we can think of victims' rights, which are concrete and particularized. Here's an example of victims' rights available under the federal CVRA. We know that an injury in fact is an invasion of a legally protected interest that is concrete and particularized and actual or imminent. Or stated differently, that an injury in fact is a violation of a victim's right that has occurred or is about to occur. And here is an example of victims' rights available under Article 6B of the Uniform Code of Military Justice, meaning that these are victims' rights available in the military criminal justice system. Again, when we think about an injury in fact, we are talking about a violation of a right, such as one of these rights displayed on the screen. Now that we have summed up the first element of an injury, we can move on to the second element of causation, meaning that there is an injury that is fairly traceable to the challenged action, or stated differently, that there is a causal connection between the injury and the conduct complained of. And your third element is redressability, which means that it is likely that the injury will be remedied by a favorable decision. So there you have it, your third and final element for Article 3's constitutional minimum standing requirements. The first being injury, the second being causation, and the third being redressability. Don't forget to look to your jurisdiction-specific laws with respect to standing because each jurisdiction is so different. And we gave you an example of how the jurisdictions can vary by the case that we put on the slide here off to the right. So you can see in this particular case, which again came out of the U.S. District Court for the Southern District of Florida, where the court said that these requirements only apply in the absence of a statute expressly conferring standing. Now, there may be reasons why you still want to brief the standing test, even if you have explicit standing, which we will talk about more in a little bit. But again, we just wanted to put this here for you as a reminder to make sure that you look at your jurisdiction-specific laws just to see if anything varies in your particular jurisdiction. Let's revisit that multiple choice question. The Supreme Court of the United States provided in Lujan versus Defenders of Wildlife that Article 3's constitutional minimum standing requirements are A. An injury that is not harmless, a bad actor with intent to cause harm, and presence in court to challenge the action. B. An injury in fact, an injury that is fairly traceable to the challenged action, and a likelihood that the injury will be remedied by a favorable decision. C. An injury, a bad actor, and ample time to challenge the injury. D. An injury, a timely challenge to the action, and proof of the injury. Good job, the answer is B. Looping back around to our second learning objective to identify key elements of standing. Now you know them. Article 3's minimum standing requirements in a nutshell are 1. Injury, 2. Causation, and 3. Redressability. Some jurisdictions have explicit standing and others do not. If a practitioner has explicit standing in their jurisdiction, they may decide to brief only their explicit standing provision and then wait and see if standing is challenged. Or they may decide to brief both their explicit standing provision as well as their jurisdiction-specific standing test. If they decide to brief both, one way that they may choose to do this is by citing to their explicit standing provision in the body of their pleading, along with a mention on how the victim meets the definition of crime victim or victim, and that the victim is therefore properly appearing before the court, and then include a footnote that speaks to the jurisdiction-specific tests and makes a showing or includes a showing of how the crime victim meets each element of that test. Standing varies from jurisdiction to jurisdiction. Alaska, for example, has a test that is far broader than the Article 3 test that we walked through today. So take a look at your own jurisdiction to see how it compares. It's time for another multiple choice question. Who might have standing to assert crime victims' rights? Select the most thorough answer. A, the victim. B, the victim and assigned prosecutor. C, the victim, victim's family, and assigned prosecutor. D, the victim, prosecutor upon request, victim's rights attorney, and a lawful representative in select capacities. D is the most accurate response. In some instances, such as homicides, the family or next of kin can assert rights in connection with the decedent victim. Let's discuss these answers in more detail. So who has standing to assert victims' rights? A victim definitely has standing, and the reason that we have legal victim is because this is a person who meets the definition of crime victim or victim in a particular jurisdiction. Prosecutors can have standing upon request, meaning if the victim asks the prosecutor to assert their rights. Victims' rights attorneys can have standing to assert victims' rights on behalf of the victim. And in some jurisdictions, a lawful representative of a victim may be able to assert victims' rights. Not all jurisdictions require this person to be an attorney, so it's very important to make sure that there is no unauthorized practice of law in any instance here. Let's revisit that multiple choice question now. Who might have standing to assert crime victims' rights? Select the most thorough answer. A, the victim, prosecutor upon request, victim's rights attorney, and lawful representative in select capacities. B, the victim. C, the victim and assigned prosecutor. D, the victim, victim's family, and assigned prosecutor. Good job, the answer is A. So what does standing to assert victims' rights look like on the ground? One way is through the filing of written pleadings in court to assert and seek enforcement of victims' rights. Stay tuned to learn more about NAVRA, which is the National Alliance for Victims' Rights Attorneys and Advocates, which contains a wealth of resources to aid you in this effort. Standing allows victims' rights to be more than just words on paper. Standing is critical to meaningful rights because standing enables crime victims to assert their rights and seek enforcement of their rights. Let's loop back around to our learning objectives. Now we can distinguish explicit and implicit standing, identify key elements of standing, and articulate why standing is critical to meaningful rights.
Thank you for participating in this online experience, and we hope you enjoyed it. If you enjoyed this tool and are interested in other victims' rights tools, please visit NCVLI's other toolkit resources for additional interactive learning exercises like this video, in addition to other tools such as flashcards, tip sheets, and much more. One of NCVLI's key projects is the National Alliance of Victims' Rights Attorneys and Advocates, NAVRA. Using its updated website, www.navra.org, NAVRA connects people committed to improving the justice system by providing the practical tools they need to protect, enforce, and advance victims' rights. NAVRA's tools include searchable databases of sample legal pleadings, legal memos, and key case summaries, as well as in-person and online trainings, partner listings, and the pro bono portal, which matches attorneys with crime victims in need of representation. And in addition to these resources and others available on our website, NCVLI is ready to assist by providing additional research and assistance that is tailored to your needs. Please visit www.ncvli.org and navigate to the online form by clicking the Professional Resources tab and then selecting Technical Assistance. Thank you for joining us.